Is 250379, Craig Finney versus the State of Iowa. For Mr. Finney, we have Stephen Drahozal, and for the State of Iowa, Louis Sloven. Counsel, whenever you're ready.
Thank you, Your Honor. May it please the court, counsel, one defendant, one act, one victim, one homicide. That's what the law is, and that's what Mr. Finney is asking this court to apply. I'm Steve Drahozal. I represent Craig Finney. We are appealing from the court's grant of summary disposition in what Mr. Finney filed or the district court phrased as, or eventually turned into a post-conviction relief case, but is essentially an appeal or a request for relief from an illegal sentence.
Just to clarify what the remedy is that you're requesting, is it only to be sentenced on the attempted murder?
That is correct, Your Honor. We are asking that the sentence in FECR 144491, the second-degree murder conviction, that be vacated, and that Mr. Finney go back to where he was before he was charged with in that case, which was, he was charged with first-degree murder, but the jury eventually convicted him. So we're just simply asking 144491, that is the sentence that we say is illegal. So we're asking that be it.
Kind of following your logic correctly, would there be a different outcome, or would your issue go away if the jury had convicted Mr. Finney of first-degree murder with which he was charged, because then it would be a Blackburger test, the attempted murder would have merged. So do you get to your result only because the jury came back with a lesser conviction?
I think of the facts of Mr. Finney's case, we do get there because of the jury's verdict. And I think, the judge, that you have hit upon an extremely important issue, which is attempted murder, of course, requires that specific intent requirement that Mr. Finney pled guilty to, which the jury was informed of and the jury knew about. He was charged with first-degree murder, requires specific intent. But the jury, after hearing all the facts, even that Mr. Finney had pled guilty to that attempted murder charge, come back with the second-degree murder charge. And that's where the difference is. So to answer your question, I think that it is possible under these facts, assuming the timeline that we have, and assuming a jury comes back with a first-degree murder case, or excuse me, a murder conviction, that we do have a different outcome, and that it is not then an illegal sentence. The reason for that is that I believe that under Blackburger, it is possible, theoretically, to commit, I would say, it would be possible for someone to attempt to commit murder, then the person, the victim later on down the road, passes away. And then you could still have, what I'm saying here is that you have that higher intent requirement. So you can still commit second-degree murder, but here we have a jury finding, which I think is key to this. This isn't a situation where Mr. Finney pled guilty to get some sort of deal by pleading guilty to second-degree murder. Jury specifically found that the specific intent had not been proven, and he was acquitted on that charge.
Of course, he earlier pled guilty to a charge that did have that specific intent as an element.
And that's one of the very unique aspects of this case. It befuddled me that his trial counsel brought this up. As someone who has defended murder trials before the jury before, obviously one of the things I'm going to attack is the intent requirement. I would say, well, he was upset because he thought that his former girlfriend or whatever, and I would probably be trying to push for a lesser included charge. But in this case, the jury was fully aware of the fact. And if we look at what was read into evidence as Court's Exhibit B, which the court took judicial notice of, the court set out the elements of attempted murder, which says the intent to kill. So you are correct that he did plead guilty to the attempt to commit murder with that specific intent requirement. Jury, however, comes back only finding malice aforethought.
I'm just not understanding how that works, because I know that at least in your reply brief, you kind of like emphasize that it's the one homicide rule that you're concentrating on and not the double jeopardy question. But if he had been convicted of first-degree murder, you'd have your same argument on the one homicide rule, at least under like how Savetti looks at it, that the attempted murder is an analog to an actual completed murder when it comes to that rule.
And I think that The court's concern about that is an issue or question that I have asked myself throughout this case is, would this apply? I would, obviously, the attempt to commit murder is not a homicide offense under the law, except the one homicide rule applies to it, which is very clear. So in the situation, had Mr. Finney been convicted of first-degree murder, I mean, I think that the argument would be different. All I'm asking the court to do is to limit its holding and its ruling in this case to these specific facts, which even the district court recognized are a unique set of facts. So I guess if you're asking, Judge, well, can you be guilty of attempted murder, the victim later on dies, and then be charged with first-degree murder? I don't think so under the one homicide rule. And what I think that requires prosecutors to do as a remedy is to...
Not technically under the one homicide rule, but under Soretti.
Exactly, under Soretti, Your Honor. So I think what that would require prosecutors to do is when they're engaging in plea negotiations in a case like this, and I want to remind the court that the state under the attempted murder case, they also got the benefit of this. I'm assuming that the victim was on board with this because they had an obligation under Chapter 915 to inform Ms. Harker about all of this. I think that when a situation like this arises and the state is engaging in plea negotiations with the defendant, the state needs to be aware of the one homicide rule. And when it's making plea offers, the reason that I think that that's important is so that the victim is on board with this, because obviously prosecutors have a duty to make sure that they are aware of what's going on, but also to ensure that justice is done. I mean, we want to make sure throughout that, because this is obviously something that's going to happen. We are going to have cases where someone is injured in an attempted murder and then they subsequently die, which is another, and I know that I keep emphasizing, the unique facts of this case. That's another very odd fact in this case, which is that we had, in many ways, Ms. Harker had some health problems. There was an organ harvest before the autopsy, which is not something that I have ever seen in an autopsy before. Obviously, the jury concluded, and we're not arguing that they should not have, that Mr. Finney did cause her death, but that's another very odd fact in this case. So,
It seems like you're hanging your hat a lot on Soretti for the one homicide rule, expansion of that a bit. Does it matter to your argument that the attack occurred, the shooting occurred before Soretti was decided? Like,
I don't believe that that alters it, because the one homicide rule has been recognized by Iowa's courts prior to that. I think Soretti, and I respectfully, I'm not asking to expand Soretti, I'm simply asking this court to apply Soretti to Mr. Finney's case. I know that the
expansion though, right? Because Soretti didn't involve that sequential kind of charging or sentencing.
Yes, to that extent, it is they are factually different. Soretti is factually different from Mr. Finney's case. I don't believe, however, that the fact that the shooting in June of 2011 preceding the Soretti case alters the outcome in this case. And I believe, Your Honor, that you had one other question that you brought up, and it slipped my mind. I just want to make sure I answered it.
I'll come back to it if it.
Simply what we are, and I want to clarify that the reason, to go back to your original question about the remedy that we are asking for, that we are asking this court to vacate the conviction in 144-491, but allow the conviction in 047-400 to stand, is because at that time he had been adjudicated guilty. We know from his direct appeal that there was a factual basis for that. He attacked that. There's no problems with that guilty plea whatsoever.
How do you distinguish Diaz and like Ruzega, those like later death cases permitting later prosecutions once the completed homicide ripens, I guess, if that's the right word? How would you distinguish?
As I pointed out in our reply brief, Your Honor, I believe that and I'm going to mispronounce the name, Ruzga is how I pronounced it. Child endangerment is what Rezga was convicted of originally. And then later on, which is obviously not a homicide offense, and that was an implication of double jeopardy, not the one homicide rule. So that's where I distinguish that case from Mr. Finney's case. So, we believe that the later conviction is the one that needs to be vacated because that is the one that contains the illegal sentence. That is the subsequent punishment, the multiple punishment, as we discussed before the district court and in our brief. Thank you, Your Honor.
Thank you. Thank you, Madam Chief Judge, and may it please the court. Counsel, good afternoon. It's a privilege to be here. Imagine a funnel. Into this funnel goes all pairs or groups of claims that pass the Blockberger test, where the greater offense includes all of the elements of the lesser. Claims that make it through this funnel, that test, you can raise a merger challenge saying that the lesser conviction and sentence should merge into the greater. And then for a subsequent prosecution on the greater offense, you can raise a double jeopardy claim. Now, this is a challenge to the prosecution, the charge, and not to the sentence imposed, which matters for illegal sentence challenges. We'll get to that later. And there's the exception for Henry Ruesga Diaz, where it ripens later. The point is that this funnel gives you access to those two remedies. What the one homicide rule does is it takes some groups of claims that don't pass that Blockberger test, where there's non-mutuality of elements, and it puts them in that funnel. And it makes those remedies, definitely makes the merger remedy available. There's a little question as to whether it makes the double jeopardy remedy available at all, but we'll assume that it does. If it does, it's still subject to the Henry and Ruesga and Diaz exception, where it ripens into murder later. The reason that this argument is difficult to follow, I think, is because it's arguing that the one homicide rule is different and allows you access to different remedies under different rules than ordinary merger and double jeopardy claims. And that's not accurate.
My head around this too, but the county attorney argued that the one homicide rule was a subset of double jeopardy. And I've actually never really thought of it as a subset, but your funnel example seems to accept that sort of subset issue.
That's where there's a question mark in the flow chart as to whether when one homicide rules go into the funnel, definitely you can raise a merger claim. That's the main function of one homicide rule. That's why I was confused when the argument is they don't merge, but one homicide rule applies. I couldn't track that. There's a question as to whether double jeopardy claims apply. The reason why, in most of the cases citing Diaz, and we collected a few in the brief to show that they hadn't been overruled by Grady, or Dixon, in most of those cases, the issue is whether the later fact of death making the homicide offense ripen creates an exception to double jeopardy. And I think it's a little inherent to, so I think that it's very clear that even when you're dealing with something that's a real lesser included offense of the homicide, the ripening of the death of the victim after the first prosecution ends gets around the double jeopardy claim, and for good reason. It's a public policy exception to double jeopardy, basically, and also that it's different enough because now it's a homicide and before there wasn't an element of death. So to answer your question more directly, I don't know of any case that argues whether a one homicide rule claim can be raised in a motion to dismiss for double jeopardy, saying that this second prosecution violates double jeopardy because one homicide rule. It's tricky to envision that because anytime the prosecutor would try to raise it, it's because the victim's death caused the homicide to ripen, and the earlier offenses aren't really homicide offenses, with maybe the exception of attempted murder. But I don't think we need to answer that question here. One reason we don't have to answer it is because this is a legal sentence challenge. It has to be. That's the only way it gets around Section 822.3. And an illegal sentence challenge can only be about the substantive legality of the sentences and not the way in which the sentences were imposed. So all the underlying facts of the case we're not so concerned with. The only thing that this court and the PCR court and this court can deal with is, do these sentences need to merge? They did. Or is there some illegality remaining in the sentences themselves that needs to be corrected? And if you read
the one homicide rule, or the Soretti somewhat expansion of the one homicide rule, is merger, right? And merger into the greater offense.
That's right. And Soretti talks about alternative remedies only insofar as it thinks merger would be unfair to the parties in their plea bargaining posture, where one party didn't get the benefit of the bargain to which they entered into if they do merger, and instead choosing to vacate. But the fact that merger was an option kind of illustrates the point that it's the same set of remedies that you get for a bog standard, merger claim under 7019 that I've been sentenced for both the greater offense and the lesser. Same kind of claim, same remedy. The one homicide rule just, says, here's our exception to Blockberger where we're going to treat these as greater and lesser, even though technically they are not. I want to point out about Ruesga that the court, and we block quote this part in our brief, the court says, felony child endangerment is not a lesser included of felony murder, but even if it was, and then it goes on and applies the Diaz exception and reaffirms Henry and says the fact that the death happens after causes it to ripen and means that there's no double jeopardy violation. So Ruesga does firmly, it doesn't talk about the one homicide rule, but it sets out the principle, it reaffirms Henry, it shows that Dixon didn't overrule or call Henry into question. And I think that the way that Soretti understands its expansion of the one homicide rule and the one homicide rule itself is that it operates as we've described, that it brings some cases where Blockberger isn't met into that realm where those claims and remedies are available, where the remedy is murder. And if you also look at Fix, it traces the history of the one homicide rule in Iowa in the common law, and overwhelmingly what it's talking about is not prevention of multiple prosecutions, it's talking about multiple simultaneous punishments and penalties being applied, that a person can only be sentenced for one homicide offense for one killing. And when the district court, after this trial in this case, got to sentencing, it did what it was supposed to do. It said, these attempted murder and second-degree murder, not technically lesser included, but the one homicide rule means you can only be punished for one of those. Only one of those convictions can stand. So we're going to merge what is the lesser into the greater, impose only the sentence for the greater, and that means both the prison sentence and the restitution, and backdate it so that you are not serving even a day more total than you should serve for this one sentence that is now being imposed, that you are now being punished for. I think that's what Soretti and the one homicide rule and all of our cases about murder require.
Just a minute about the restitution issue.
Yeah, I'm prepared to say that there is a sentence in the ruling, the first ruling, not the re-ruling, that says to the extent that restitution is raised, there's only one restitution award here, so I think it's minimally preserved. But what the court says in one sentence is correct, that restitution was identified but not imposed in the first FECR case. When they got to sentencing on second-degree murder, they imposed the actual damages of restitution as described in the first, identified in the filings from the first case, together with the $150,000 mandatory restitution that's unconnected to actual damages. And that's the single sentence for the second-degree murder is both of those kinds of restitution. And I think that's proper. Okay, thank you.
Thank you. Your Honor, to address counsel's point about Mr. Finney not spending a day more in jail, I respectfully disagree with that. I mean, Mr. Finney was sentenced back in 2011, approximately 4 months after the event, before Ms. Harker died, and he's in prison serving a sentence during that time. So under the state's logic, Mr. Finney is being punished for the death of Ms. Harker for approximately 2 years before Ms. Harker dies. On top of that, we've now got a sentence that is double in length what Mr. Finney was originally sentenced to when he is sentenced under the second-degree murder. And on top of that, we have the $150,000 in restitution, which I believe is, unlike most restitution, actually punitive. And the Supreme Court has held that $150,000 is punitive. So he is suffering, he is being punished beyond what he would have gotten. He has been deprived of the benefit of the plea deal that he entered into with the state, and that the state entered into with him. When I say that he's being deprived of that benefit, I want to be clear that this is not Mr. Finney trying to manipulate something and saying, oh, I'm going to hurry up and plead guilty to attempt to commit murder because the penalty is less than if she dies later on and I'm found guilty of either second or first-degree murder. This is a plea negotiation that the state also derived a benefit from. However, if the court does not hold that the one homicide rule applies under these facts, then Mr. Finney is in fact deprived of the benefit of the plea negotiation.
But under your argument, there's simply no consequences for the later death of Ms. Harker.
I understand that, Your Honor, which is why I go back to the point before that when the state enters into plea negotiations with defendants under situations like this, and let me give you an example. So that I'm not saying, oh, too bad, so sad for the state, my client comes out ahead. Although I think I could make that argument, but I understand that the court is not going to accept that argument. And Mr. Finney understands the court's not going to accept that argument. So what the state can do in situations like this, when we're dealing with a victim like Ms. Harker, who has issues, who has ongoing health issues, that she has not fully perhaps recovered from the gunshot wound from June of 2011. The state is able to engage in other plea negotiations to have Mr. Finney or the defendant plead guilty to offenses that are not covered by the one homicide rule. Example, we had two, in this case would be a perfect example of that. We originally had two victims that Mr. Finney shot at, or I would say was accused of shooting at. He didn't plead guilty to the second one. There were multiple offenses that Mr. Finney was charged with that he could have pled guilty to, that could have given him an extremely long prison sentence, that could have gotten
Charges, I take it.
they would have been lesser charged. I'm thinking things like willful injury, things like that, combined with going armed with intent, something like that, that you could stack on top of each other consecutively to give him, yes, lesser charges, but that are outside of the one homicide rule. And I think that when prosecutors are making these plea negotiations with defendants, they simply need to be aware of the one homicide rule. And that way, we do not end up in a situation where we have somebody who hurts somebody who subsequently dies and then they face no consequences. Had Mr. Finney pled guilty to these other offenses that were not covered by the one homicide rule, then the subsequent prosecution and the subsequent conviction would not be problematic. He would have been pleading guilty to what he had done. I'm going to use willful injury as an example. He would have been in prison. Ms. Harker, unfortunately, later on passes away, dies as a result. Then the state can come in and charge him because he has not, because those previous offenses were not subject to the one homicide rule.
I understand your logic with regard to the sentencing. To be sure, with a single homicide rule, you can't have multiple punishments, but the remedy for that is merger, which means taking more than one and converting them to one. His sentences were merged here, so there weren't multiple punishments.
I would go back, Your Honor, to, again, my point earlier, which is that he's already serving a prison sentence that this sentence merged with before.
Credit, the way they worked it out here was he was given credit for the time served from day one.
Respond, Your Honor. You are correct on that, but what I'm saying is I logically don't understand how someone can be imprisoned for murder, which he was under this merger doctrine before Ms. Harker died. And our reliance upon Soretti, I know that we are leaning heavily upon Soretti, but I believe that the Supreme Court's legal reasoning and in Soretti is strong enough to support the facts of this case applying to Mr. Finney. Thank you.
Thank you both for your good work on this case. We appreciate it. We will consider Finney versus State submitted, and we'll have a written decision as soon as we can. And we stand ready to adjourn.